Welcome to People Want to Know, an immigration segment where we take your social media questions and attorney Jessica Dominguez answers them. Thank you for joining me week after week on this beautiful segment where we answer the community's questions.
It's my pleasure to be here. Thank you.
This week on People Want to Know, we're going to be going over the new waiver process that was introduced March 4th of 2013. Many of you have been sending us questions about some confusion about the difference between the I-601 and the I-601A waiver. This week, Italo writes to us on Facebook and he wants to know, I came to the United States without documents in 2003. My girlfriend is a resident. His question is, if we get married, would I benefit from the I-601A provisional waiver, or would I still have to leave the country?
In order for people to benefit of the I-601A waiver opportunity, they have to be the immediate relative of a U.S. citizen. Three groups of people that can benefit: spouses, children who are under 21 and single, and also parents. In this case, if Italo were to get married to a legal permanent resident, he would not qualify to apply for the I-601A inside of the United States.
So he would have to wait for his legal permanent resident wife to become a U.S. citizen.
That would be a very good advice for him.
Okay, great. How is this process different between the I-601A and the I-601?
The difference is that in the situation where I have mentioned these groups of people that are related to a United States citizen children, they can apply for the provisional waiver here inside of the United States. But let's just say you have someone like Italo who gets married to a legal permanent resident, and for one reason or another, she cannot become a citizen. What do we do then? He can apply for what we call a consular process and go outside of the country to his interview. At the time of his interview, he would then be explained about the 10-year bar because he resided in the country over a year without documents, and they would request the I-601 waiver. And that's when he registers his waiver outside of the country, and he has to stay outside of the U.S. until his waiver gets approved, and he can then come back to the U.S.
Great, thank you for clearing that up. That's very important information. But for both of these waivers, you do have to prove extreme hardship, correct?
Absolutely, and that's a really good point because we want to make sure that before you're looking into the I-601 or the I-601A, that you make sure that you have the relative who's going to help you qualify to prove the extreme hardship. For example, in the case of Italo, we already know he's going to be getting married to a legal permanent resident, but there's so many people out there who get married to a United States citizen spouse. In both cases, they would have to prove extreme hardship to the spouse. And that evidence is of the utmost importance. Right. That, as you know, we already have a YouTube video with some examples.
Thank you. If you want to watch that video, you can watch that video right here. So I think I got it. I think I understand this. Italo would have to, unless his wife became a U.S. citizen, would have to exit the country, apply for a waiver called the I-601, and that would hence get rid of the 10-year bar.
That's correct.
Well, thank you. Thank you for joining me, Attorney Jessica Dominguez, week after week. Do you have anything to say to the people that watch us every week?
Yes, thank you so much for your questions. Thank you for following us. And of course, thank you to my son, JP, for being here every week with me.
Make sure to watch all our other videos where we go over the I-601A waiver that are appearing right here on the screen, and that you can get many more of your questions answered regarding this process. Thank you for joining us. And we'll see you guys next week on People Want to Know. Don't forget to like, subscribe, and share these videos. Thanks again.